So good afternoon, everybody. Again, if we haven't met before, I'm Francisco Servent. I am the founder and attorney at Keystone Law Firm, and I'm here today to bring you what I hope is a better understanding of how the Secure Act, which went into effect January this year, 2020, how the Secure Act is affecting my clients, you guys, with regard to your IRA, 401k, those types of retirement accounts. So one of the biggest changes that has happened to how those accounts are taxed, lots of things. One of the biggest changes I've seen in my whole career with regard to retirement specifically, because it affects everybody who has those accounts, no matter what size, no matter how big those accounts are, how small they are. It affects 100% of all of us, and nobody is exempt from that. It's not just a tax law that affects that top 1% at all. This is every single account holder. So what I'm going to do today is I don't have slides. You're just going to get me live with the whiteboard, and I'm going to go through and explain what the problem is that created and what our proposed solution is, what I think is a good solution for you, for your family to consider. I hope by the end of this, you have very clear understanding of what the solution is and whether or not you need it. And if you need it, I'm going to show you how we do that for clients. So stick around to the end. If you know you need this, if you learn through the course of today that, oh my gosh, we got to fix this problem, then I'll show you how we do that and give you a couple options to get started. The big thing is that the Secure Act went into effect this year. And what it did is it totally changed how retirement accounts are taxed. And so there's two time periods that these accounts we have to consider. And in the timeline of that account, right, it's an IRA or a 401k, you guys all know that when you take money out of those accounts, you pay taxes on those dollars, right? These types of accounts are highly regulated because of the tax-free nature of these accounts. So when you put money in, you get a tax deduction. When you get money out, the whole distribution is taxed. What the Secure Act, what I'm going to talk about today, is how it taxes those accounts, not during your lifetime, but what the taxes are for your beneficiaries. Okay? That's what this is about. If you have retirement accounts, 401k, IRA, if you've moved any of those into an annuity, and now it's an annuity, this is for you, okay? Generally speaking, I want you to know that if you've got more than about $150,000 in all those accounts or annuities combined, you have to fix this problem. Unless you're just, absolutely you're going to drain those accounts here in the next 12 months. If you're not going to drain them in the next 12 months, if they're going to last longer than that, you've got to fix this tax problem, because here's what is now the law. The current law, again, this went into effect January of this year, so it's already the law. The law says that now when your beneficiaries inherit these accounts, okay, it goes down to them, whoever they are, whether it's, the only exemption is your spouse, and there can be an exemption if it's a disabled child, which I don't have time to get into today, but if it's anybody else, generally, right, it's your kids, they're going to distribute, if you've got 3 kids and you're just giving it a third to each of them, they now have to take and cash it out 100% of it within 10 years of your death. Okay? The big difference is they used to be able to do this. They didn't have to do that at all, and they could distribute it out of their lifetime. They used to be able to defer the taxes for the rest of their life. That's a huge tax savings. So where one I had a client whose dad passed away last year, 2019, before this went into effect. He's going to be able to take that whole account and distribute it over his whole life. He's got another 40 years where he's going to be able to distribute it. That account is going to grow because it's tax deferred for 40 years. Huge tax savings for him. Huge tax savings for him. Okay, that account, if you would have started, I'm going to use fake math, $100,000, 40 years later, that account would be worth about $1.2 million. At a very conservative investment rate, right? Now your beneficiary inherits $100,000 in an IRA. You know what that account's going to be worth in 40 years? It's basically going to be worth zero, because at year 10, right, they're going to get to year 10, and it's all cashed out. Have to be mandatory. Now there's no waiting for distributions over the course of their lifetime. This is going to go all cashed out at year 10. That's a big problem for two reasons. Number one, it increases the tax bill. So on this account, right, $1.2 million 40 years later, now it's going to all be cashed out. And you know what happens when beneficiaries cash money out, they don't reinvest it. So it's all going to be worth zero, but that's kind of the tax situation driving the result. The other problem is that, you know what IRAs and inherited IRAs in Arizona used to get? Well, I should say they still get, but it's not going to be in an IRA anymore. Now what's going to happen is what happened to this one client. This guy, he left about $200,000, and he had 5 kids, 1, 2, 3, 4, 5. Passed away, and all 5 kids get an equal share. Didn't have any protections in place. Secure Act requires this thing to be fully distributed. So there's no, it doesn't stay in an IRA. You know what IRAs get? They get total protection from creditors. So a creditor sues you, a lawsuit, a car accident, anything, they can't get it. They can't get to your IRA. The law says if you leave it to a beneficiary and they get sued, okay, if they're in the state of Arizona, they don't take the money out of the IRA, they leave it in there. If it's still in that inherited IRA, the creditors can't get it either. The problem is now with the Secure Act, there's no more inherited IRA after year 10. Not allowed. That's now federal law. So 10 years is the only time period that those funds can be protected from creditors. And, I get it. It's like, well, it's their money. If they lose it, that's their problem. And I hear enough people say that I have to address this. I don't work with clients, and I see names on the list here, right? I see who's on the list, who's attending today. Really amazing. Y'all are here. Thank you. Good job. You guys are the cream of the crop, right? A lot of clients are here to learn about this space. The clients we work with, I know you guys, and yeah, that's a easy way to say I don't want to deal with it, but I know you. You care about your kids. You care about your family. I mean, the last thing you want is we had a guy who got in a car accident at Sky Harbor, and you know how you're pulling in to pick people up? Well, he clipped a car. He rear-ended a car that was parked in front of him because he was trying to squeeze in. And, of course, hitting a car is not that big a deal, but there was somebody standing behind that car unloading their luggage, and he crushed their legs. And complete accident. I mean, total freak accident. This is a guy in his 30s. He's got little kids. He's got a family. And now, complete accident. He's getting sued. This has been resolved now, but he got sued. Obviously, he got sued. The guy he hit and broke his legs and crippled him for life was a cardiac surgeon and completely destroyed this guy's ability to earn an income for his family. So now we've got this guy being sued, this cardiac surgeon who was, he had dreams, he had aspirations to provide a life for his family. He's getting sued, got sued for multi-millions of dollars, and had to deal with that. If your inheritance would go to a child who was in an accident like that, who was causing an accident like that, you would want them to have something to start over with. And that's what you give with all of your estate planning, right? I truly believe your estate planning is your last chance to make a difference. And the better job you do at it, the better legacy, the better you can give them that long-term security. We pray they don't have any of those accidents, but if they do, the nest egg you leave them, whatever it is, that can be the little nest egg that saves them in that moment of just absolute despair when they did something totally on accident. So, yeah, I get it. We want to say, their problem. But while that's true, when you're alive and you're watching your loved ones struggle, if you can help them, you do. This is the same thing. The Secure Act completely took away the creditor protection from inherited IRAs. So I want to show you the difference here. What do we have? We have your revocable living trust. You all should have those in place. And this is, we teach on this, we talk on this a ton. So, this is where your house goes. This is where your bank accounts go. This is your car. This is your life insurance. This might be if you have stock or brokerage accounts, right? All of these things are going through your trust down eventually to your beneficiaries. Well, where do your IRAs live? Your IRAs and your 401ks, they live out here. They live out here in no man's land. And for a few years now, maybe 5 years, I have said, do not put these in your regular trust. My advice, and all of you right now listening, if you have your IRAs going to your regular trust, please change that. Please, it is not a good result. It can waste a ton of tax dollars. It's not a good strategy. You don't fix problems by doing that. Keep it on its own. And your two options, really, one is just name your beneficiaries individually on there. Okay, name them as individuals, as people, individual. Or you're going to have this go to what we call a standalone retirement trust. And I'm going to spend now a few minutes telling you how that works, okay? Because that, I think, is a good solution for the problem that the whole Secure Act created. It was already a problem before, and we've been using these for years. It's a bigger problem now, and I think more people need to take advantage of this strategy. So you need to know about it. So stick with me while we learn about this, okay? Your IRAs and your 401ks, they're calling you. They're saying, save me, don't leave me out here hanging. They don't want to be left out in the dust. Your IRAs, they're like naked accounts out there. They have no trust around them. Get them covered up. It's getting cold outside, okay? That's what we're going to talk about. We're going to talk about how to cover up your IRAs and your 401ks, how to blanket them in some protection. All this stuff, it's good. It needs to go through your trust. But that's not what we're talking about today. Okay, your two options. Option A goes directly to your beneficiaries. You don't need my help to do that. You don't need anybody in my office. You don't need our help at all. You just call Fidelity, you call Keystone Law Partners, you call whoever it is managing your IRA and your 401k and say, hey, I want to change my beneficiary. Please make it my spouse, make it my kids, whoever you want to name on there, okay? You just call them, get that done. Don't make sure it does not go back to your regular trust. Don't do that. We all good? We clear on that? Okay. Either goes to your individuals, and now remember, if they inherit that, they're getting no tax savings, and they're getting no creditor protection. They're getting no spouse protection should they get a divorce, right? They're going to make a good argument. It's commingled property, and that's going to end up going to the ex. No protection from lawsuits, none of that, okay? But that's the regular thing. What we're going to talk about is this guy, this retirement trust. The retirement trust is so simple, and yet my stupid industry has made it so complicated. You ready to learn what it is? It's going to take me like a minute. There you go. Ready? Standalone retirement trust. Watch. Like this. And then your beneficiaries. It's the same thing as your living trust. It's basically the same thing. Except inside here, we have to build all these crazy little clauses and legalese that comply with all the tax rules that relate to IRAs and 401ks. Lot more tax language in there than you ever want to know about. If you want to know about it, then you have to join and become either a CPA, financial advisor, or an attorney, and then start coming to the CLEs that I teach to those people. And I'll teach you what that legalese and the tax planning language means. But my clients, you guys, my friends, you do not need to know all of that. Right? What it is it's taxes and taxes and taxes, and this gives you the ability to avoid as much as possible on the taxes. But the real key for me is the protection from creditors, from divorce, from lawsuits. It would make me just so happy if all the other lawyers out there couldn't get after your family. I've literally had clients who had retirement trusts and they passed away, and it's been in the process of being administered. We had one who went to her sons, and while they were getting it all set up and distributed 3 ways, we got a letter from the bankruptcy court that said, hey, one of these is in bankruptcy. We hear he's entitled to an inheritance. We need you to send that over to us. And we got to send back a nice little letter that said, nope, bam, bam, bam. Here's the reasons why under Arizona law, that beneficiary, totally protected. His inheritance did not go back to bankruptcy. It was held back, protected in his share of the retirement trust. He got to clean up his bankruptcy mess, and it was there to help him restart over, start his life. And that's the power of this thing. Same thing in divorce, right? If a beneficiary ends up filing divorce or gets married and then later gets divorced, their inheritance out of your IRA, your 401k, is and stays their separate property. It's like a prenup that you get to give them. Okay, you get to give it to them whether they want it or not. And it keeps it separate property so it can't be lost. That's the power of the retirement trust. Now, what does it say in here? Well, it's going to say a couple things. It's going to say a bunch of things. The key ingredients that you're responsible for, the key ingredients there are who is the trustee and who are the beneficiaries. That's it. That is your job as the client. Number one. Number two, who are the trustees and who are the beneficiaries? What many of our clients do is they take their retirement trust and they make it literally mirror and match their living trust. So if in your living trust you said, hey, spouse first, this child, as the backup, and you have your order, you can just say, hey, make it match that exactly. And that's really common, and it makes sense to do that because, that same person is going to just be doing the job along both trusts. Beneficiaries, if it's just all going to your kids or your grandkids in your regular trust, you can do the same thing here. It's not really any different. The only sort of contingency or I'm not sure the contingency is the right word, the only unique pattern that might change this whole recommendation is if you have a lot going to charity. Charities are great. We love charities, right? Leave something to your church. Leave something to the causes that have been important to you that you support right now. Charities need our resources. When we pass away, you know, we're going to peel off and give some to charity. I think that's something smart. I think that's a legacy move. I think that's a good move. But if you have a charity as one of your beneficiaries, you don't do that through a retirement trust. You don't. You actually do that, like what we said here under that first option, you actually do that directly with the beneficiary form at Fidelity, at Schwab, at Keystone Wealth Partners, whatever. You do that, you say, I want 10% of this IRA going to my church or whatever on that form. And that's the best tax result there. Then you say 90% over to my retirement trust to go to my ultimate beneficiaries or something like that. But this is it. Once you make these two choices, you are done with your retirement trust. That's really it. You don't need. It doesn't need to be more complicated than that. I promise you, it shouldn't be more complicated than that. Now, I get that there may be some sort of fear and trepidation in you with like, oh my gosh, this is such an advanced, complicated thing. And it just sort of locks us in sort of, what's the word? What's the phrase? Paralysis by analysis, right? We get kind of overanalyzed. We just can't even make a move. This is the kind of thing, and that's the kind of fear that I really blame my whole industry for. I absolutely blame the whole industry for making you feel that way. You don't need to feel that way. A retirement trust is a pretty simple strategy. It really is just like your living trust. It's just built to have the tax language necessary for IRAs and 401ks. So, it's like you have a minivan, which is good for lots of things. It's good to haul the kids around, when you have to go to soccer practice or school. It's good to, pile in and go to church on the weekend. It's good to, it's even fine for like groceries or road trips or whatever. That's your living trust. Just a living trust. It's just a minivan. If you need to haul a boat, you're not going to, you might hitch it to the minivan, but you might blow the transmission. It might not work. And so when you're going to hitch the IRA or the 401k to something, we're just going to change it a little bit and hitch it to a truck or an SUV. It's just built for it, okay? And that's all this is, just another kind of trust, but built specifically for IRAs and 401ks. Don't be over-intimidated by it. All your choices is do I use the same trustees as my living trust? And what about my beneficiaries? Is it going to be the same, or are we going to make some tweaks there? The other thing, you're all here, so I probably don't need to mention this to you guys. You guys are the fearless crowd, the hundreds of other clients who aren't here. Shame on them. You can all shame them when you see them. You guys probably don't need this message, but I know that maybe you need this for the people you talk to in your life. There's a general taboo over talking about things that have to do with our own death. And especially right now in the midst of the pandemic and obviously a very stressful season for a lot of families, I just want to give you some comfort and reassurance that if there's anybody who can tell you that that taboo is a superstition that just isn't true, I think it's me, because I've been talking about this every day, all day, with thousands of families, and it hasn't hastened my demise. Like, I'm still here, I'm still kicking. You're safe. This can be as comfortable of a topic as you want it to be, or it can be as uncomfortable as you make it. So just let it be what it is if you need to have this conversation with somebody. Now, this is all, this is all sort of, I'm coming to you because there was the big law change in January about these accounts, the Secure Act. And yeah, laws do change, and I get that there's, there's this, with the new president coming in, there is going to be a lot of new proposals. And, I know for me, I'm always looking ahead, like, what are they going to do next? And I need to make sure to stay ahead of that for you guys. Well, what if they change this whole thing and that, this whole strategy becomes moot? It's just now a big pile of garbage. And I get it. Like, that's a legitimate concern if that's something that you're thinking. If that is something that you're thinking, I just want you, I hope this isn't the first time you've heard me say it. I've said it. I preach on this. This is my biggest soapbox, is that your estate plan, it cannot be seen. You have to see it as something that always needs to be managed. It always needs to be looked at, maintained, and updated 3 times, right? If the laws change, yes, right? We don't have a crystal ball, but we have to keep it current. If your life changes, okay, your life changes, which your bank accounts, your finances, your assets, whatever, right? If anything in your life changes, or I figured out another L. Finally, I figured out another L to make them all 3 L's. If your likes change, if your likes change, if you change what you like, I don't like this trustee anymore, I like that trustee. I don't like this child anymore, I like that child anymore. If your likes change, your plan needs to change. And so you've heard about our Trust Care program. For those of you on the Trust Care program that are current with that, get your update meeting scheduled to talk about this, okay? Please get it scheduled to say, do I need to do this? Or I know I need to do this. Here are my questions that I need to make a decision on, how the beneficiaries are set up or whatever. Our Trust Care clients, they get that annual review, so we make sure nothing gets out of date. It is exactly for these reasons that we have to do that. And yeah, they could come out next year and change everything 180 degrees and just rip it all apart, and we're all stuck going, well, what the heck? But they typically don't make that kind of a change. They typically make changes that are small enough that we just have to adjust the strategy a little bit. This strategy, this retirement trust, has been around for about since the mid to late 90s. It's been a solid strategy since then. The law change in this year from the Secure Act just made it more important than ever. So it's not really a new thing. It's just kind of more important that more people get this done. And our criteria is if you have about $150,000 or more in those retirement accounts, you're not going to hear a different message from anybody in our office. We think you need one. We think you need one, period. We just black and white. The cost of setting it up is way worth protecting that whole bucket of money instead of leaving it out there just naked in the cold with nobody to protect it. So what I want to do next is switch gears a little bit. I'm doing okay on time. And I want to tell you guys, if you need this, here's how we set this up for you. Being that you already are our client, we've already done your living trust. I'm assuming everybody on here is already an estate planning client of ours. If you're not, then you can still do this, and that's one of the options that I'm going to give you. I created a special part of our website for you, and if you have a way to go to another part of your computer to look at this, you can go to this part of our website. Let me actually give it to you. It's our main website, Keystone Law Firm, and then it's .com. What you're going to add at the end there is SRT. So you can go to that right now. I want to show you what's on there because there's 2 ways for us to create your retirement trust now. So if you went through and did your revocable living trust with us, and we talked about that, we could have just done it through that process. There's a significant discount, significant savings if you do it during that process because it's obviously super streamlined for us to do it at the same time. Coming back later is what this is looking like. So there's two ways to do this. The first way, we're calling it, it's kind of a new option. We're calling it self-guided, okay? And then the more regular option is now what we're calling this white glove option. I created this because I realized you guys aren't doing this. Like, not everybody is getting it put together. And so I created a self-guided option that you can basically, if you've got a super clean, simple situation, you can go through and essentially do all the heavy lifting on your own, make the decisions that I just described to you, come back to us and say, here it is, can we please get these drafted and signed? Beautiful. So what it is you get the retirement trust, okay? And that's got a value of $1,977. What I've created as part of this was a lot of fun for me because I love this stuff, is I've created 1, 2, 3. You get 3 different training booklets. Maybe not training booklets, maybe not training is the right word. Information booklets for you to be able to read, and it's not in legalese, it's not tax language and tax code. It truly is something you can digest. You get 3 booklets. We've got 4 videos of me on the whiteboard just explaining everything that you need to know about the retirement trust. We will conduct an official signing meeting. Holy moly. And all of these things, let's see, the booklets themselves, I can't do math on the fly, but my math isn't going to add up, so don't try to hold me to it. I think these 3 things, they are all worth $36.50. And so here we've got $6,247,000 in value under this self-guided option. And what we're doing is your cost is only $1,000, okay, for the self-guided option. Really good deal. You get this done once and for all. It's done. You don't have to wonder what you need to do next. It's done, right? And then this is now part of your family's legacy. The IRAs, the 401ks, they're not out there naked in the cold anymore. They're protected. All of the white glove services include everything that we just, that I just described over here. But it includes a whole lot more because we know some of us just need more time and individual conversations, individual attention, and we're happy to do that. It's a bigger investment. You get multiple meetings now where we will do design with you, strategy, draft, reviewing drafts, all these things, and that's an additional value of another $6,850, and the total value here is $13,097. For anybody who just wants that one-on-one time, repeatedly with some space and some opportunity to think, slowly and consider different things, and what if I do this, and what if I do that? Absolutely, we're happy to do that. The investment for that one is $2,500, okay? And this is a flat fee, you take advantage of the flat fee, not nickels and dimes, charging from an attorney. These are flat fees for your family, for your benefit, okay? Right there, KeystoneLawFirm.com/SRT. You can go there. It details all of that, okay? Read that, review that. If you want to take advantage of this, there's a link, okay? There's a little link right in the list that says Learn More. I think that's what it says, Learn More. Click on that. It'll take you over to the payment page, enter your payment, and my office will get in touch with you to schedule your signings or your appointments, whatever you do. Under this model, self-guided, it is self-guided. You're going to get an email course delivered to you with all those materials in bite-sized fashion, so every few days you can do the next step, do the next step, do the next step. Once you've been through all 4 modules, then that's when your signing meeting gets scheduled and you're going to come in, sign those new documents, okay? That is all I had for today, guys. If you want, there's what else? There's also about 45 minutes of more audio training links on that website. So you can go there and listen and learn more about retirement trusts and, just kind of recap some of the things we've talked about. But that is it. That is all I've got. I'm glad you guys came. I hope you guys have a great Thanksgiving next week. God bless you all. Bless your families. And, hopefully we can kind of coast in through the holidays, get to the new year, and start to see, some light. Start to see that this isn't all going to be, 2020. We're going to get to 2021. We're going to get to a new, fresh start. And I'm excited for all of you to be able to spend time with your family this holiday. Hopefully you do get to do that. None of us are guaranteed a holiday next year. And so I hope you get some time with your family and your loved ones. All right, everybody. Thanks for coming. Have a great rest of your day, and we'll be in touch.